All right, so let's take a look at Chille's appeal of his Los Angeles case involving Blue Bacon, and it looks like Team Skeptic, and also a couple other people. I really don't know. I mean, I know obviously Team Skeptic. I didn't know his actual name, but I'm told that this is his case. And Michael Pieratini, I have seen him a few times on my channel with Blue Bacon. So let's take a look, and let me give you some perceptions that are hitting me right now. And all we have at this moment is Chille's notice that he's appealing. So you first file the notice and you have a statutory deadline of 60 days. And if you blow that deadline, you blow the appeal. The appellate court will lack jurisdiction to even hear it. I was just in front of the Court of Appeal in Los Angeles where he's appealing this case. I won they appealed my anti-SLAPP motion when I kicked the ass of a guy that wanted to sue for millions. I jammed that anti-SLAPP down his throat, and rumor has it that he is still trying to shit it out today. My respondent's brief was so crushing that I did not even have to provide any oral argument at the hearing. I merely submitted to the presiding justice. So let's take a look at this. This is a rabbit hole, and it's taking me more time than I want because I am taking a little bit of a break between my trial right now in downtown LA where I'm waiting the judge's decision. And let's first look at his appeal notice, and then we'll start from there, and I'll try to move as quick as I can. So this is the notice of appeal. All right, go right here. So Chille drafted basically his own notice of appeal. Not a good idea. I would never recommend it. The optional form is the AP002, which is right here. And notice you just have check boxes. A lot easier to do check boxes than it is to forget something. For his sake, however, they have wide latitude. They have latitude in the interest of justice to preserve and read expansively a notice of appeal so as to avoid cutting off appellate rights. But why put yourself in that box? So I gave you the California Rules of Court for the 60-day hard deadline. This 60th day ended yesterday on the 17th. Hence, I've decided to upload the video and do it on the 18th because that 60-day period ran as of yesterday, and there was no reason for me to do the video yesterday and alert Chille to any problems that he could probably fix with an amended appeal. You got it. Okay. So here's Chille, November 13th. He filed it early. That's okay. No problem. It's filing late. That's the problem. And it says here, notice is hereby given that plaintiff and appellant Jose DeCastro hereby appeals to the Court of Appeal, Second Appellate District. Well, where else would you be appealing to? But that's okay. From the judgment entered on September 17, 2025. The deadline to file the appeal is November 17th, since it fell on a Sunday. And that moved it one more day under the rules of court, in civil code, actually. You know, you move it, you don't end on a weekend or a national holiday. So I have immediate questions about how this is drafted. Reverse the trial court's vacatur of appellant's voluntary dismissal of defendants Pieratini, Clement, and Omo, filed April 15, 2025. At first glance, that's outside the 60-day rule, so therefore the appellate court would not be able to hear it. However, the ruling itself came down on September 17th, another one on the 18th, and therefore it would, I think, probably be swept in under that. But here's what he's trying to say, and I'll show you the docs. He voluntarily dismissed them without prejudice because they had Pieratini had a motion for terminating sanctions pending. And I think it was 9 days before that motion was to be heard. Chille came in, said, you know what? I'm not going to let the case get dismissed on terminating sanctions against me. I'm going to file a request for dismissal without prejudice so I can file the case again as long as it's not time barred. That sounded like a slick move. We'll get into that. Reverse all terminating sanctions and monetary sanctions totaling 15 grand imposed against the appellant during his 117-day wrongful incarceration. Well, that is not written very well, because if you're reversing the terminating sanctions, then you're reinstating the case against you. You're bringing the defendant Pieratini back in because he actually got the terminating sanctions. So are you really just looking to reverse the award of sanctions? But that's not what you're saying. You're reversing all terminating sanctions. And because it's not clearly defined, it would mean also that you want to bring Piratini back into the case. You also said during his 117-day wrongful incarceration. I think we have some errors in dates there. As he was convicted on March 19, 2024. It was overturned on July 10, 2024 by the most appealed and overturned judge in Nevada history. He had an attorney that substituted in, I know, on July 5th and 2024, right before, while he was incarcerated, he had a lawyer. And then also the attorney substituted out April 15, 2025. So I was looking at the docket to see when of this stuff was happening, and some of it was happening right before he was incarcerated, like a motion for sanctions was right before he was incarcerated. The MSJ was filed while he was incarcerated. And I would say that Chille's got an excellent point here. If you're going to try to pile on when the guy's in jail, then I think you got a problem with that, because, you know, how's he supposed to respond if he's locked up? Okay. I mean, that to me is going to have a problem. You would want to extend it and give him more time. Okay. But I'll get into that too. I'm just kind of highlighting things right now, guys. Then restore appellant's case against defendant Catherine Peter and remand for proceedings on the merits. I don't understand that, because it looks like you took her default in March or June of 2023. So she doesn't have any participation in the case because you took her default. Are you saying that you want to unwind the default? Well, you could have done that as well without having to file an appeal. I'll also talk about some of the problems with that. Number 4, award such other relief as the court deems just and proper. That you find in a prayer for a complaint, not in a notice of appeal. They don't do that. So that's all wrong. Okay, grounds for appeal. Well, okay. The trial court violated appellant's constitutional right to due process by imposing terminating and monetary sanctions for conduct physically impossible during the appellant's 117-day wrongful incarceration. Conviction later overturned on appeal. The court further erred by vacating appellant's absolute statutory right to voluntary dismissal under Code of Civil Procedure Section 581B1. So I just wanted to show you what he's talking about, what Chille's talking about. An action may be dismissed. Notice the word is may, means it's permissive, in any of the following instances. 1, with or without prejudice upon written request of the plaintiff to the clerk filed with the papers in the case, or by oral or written request to the court any time before the actual commencement of trial upon payment of the cost, if any. So in court all the time, you know, you can make stipulations and you can just say, you know what, judge, you can dismiss that right now. Judge will say, okay, that's dismissed. You're the plaintiff, you're the captain of your ship. But there's some rules here. Certificate of service, I will get to that. He's only, I know this lawyer, he's a very good lawyer. He was Blue Bacon's attorney. You know, you're supposed to serve everybody, but that is not fatal to a notice of appeal. It is an error in the rules, and they would ask you to fix it, which if you don't, they may get you in more trouble. Next thing here is it has to be an appealable order. Well, when you serve people electronically, it's very preferable that you use electronic service documents that the appellate court has already created for you. They're optional, says that they're optional right here, but everybody knows them and they're very specific and you don't leave out things. The appellate form, like I talked about, this is kind of an interesting thing here where there's an internal inconsistency. On the one hand, it says that it's for optional use, and this was the year it was approved by the Judicial Council. But at the same time, it says it's mandatory, must be filed in the Superior Court. So they're saying, don't file this with the Court of Appeal, file with the Superior Court, and they're saying this form must be filed. So how is that form optional? That's something for another day. But notice that you can just check boxes and this Code of Civil Procedure sections that you think warrant the overturning of the trial court's decision. Also, you know, there's some other missing language that is supposed to be in there. But anyway, that's what he could have used. That's what I've suggested he would have used, but he didn't. Okay, fine. Now, let's take a look at Chille's statement about the violation being violated and his violation of his due process rights, and that he had an absolute right to dismiss. an absolute statutory right to voluntary dismissal. Anytime you use language like that, you are guaranteeing to have the eyes upon you. There's very few things in the appellate law, the statutes and stuff that make something absolute. There are, but it's rare. Okay, let's go to now this section. And this is what I call the rude awakening. Beware of the rude awakenings. Rude awakenings. A rude awakening is by definition rude. Okay. So Chille dismissed his case on the eve of the terminating sanctions motion from Blue Bacon. And I wanted to test the theory that was there an absolute right under 581? Well, here's 581b1. And here's where things get really messy for Chille. Courts have also denied the plaintiff the right to dismiss an action without prejudice when dismissal, quote, would frustrate a statutory scheme. For example, a judicial arbitration of the plaintiff's small claims case was favorable, blah, 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 blah. Permitting the plaintiff to voluntarily dismiss without prejudice, the court explained, would defeat the express legislative purpose of expediting and removing complexities from the judicial process. But that was small claims. And in here, allowing plaintiff dismissed after hearing on summary judgment motion began would eviscerate the summary judgment procedure. So imagine you have an MSJ, hunting you down, and as you see the court's tentative the night before that says the case is going to be dismissed and you probably pay attorney's fees, or something like that, you decide that you're going to dismiss the case voluntarily and refile because you aren't you're outside the statutory scheme of statute of limitations. Well, they're saying, wait a minute, you're trying to get around the MSJ, which would dismiss your case. You want to file it again later. So we're going to allow that MSJ to be heard, and we're not going to allow you to dismiss. So there is no absolute right. An example would be an MSJ. And there's no absolute right in the face of a motion for terminating sanctions, which is exactly what you were facing. You had no absolute right to dismiss anything. Let's get to that. It says, plaintiff who failed to comply with the discovery order could not dismiss his complaint just prior to a hearing on the defendant's motion for terminating sanctions because the tactic would simply defeat the trial court's power to enforce its discovery orders. So we're going to show that Chille actually was facing down terminating sanctions for failure to comply with discovery orders. And so Pericini's lawyer made a very, very smart move. And he said, you know what? You've blown these discovery orders. These are violations of the court. I'm now going to try to get you the case thrown out. And what Chille said to himself was, because I got this terminating sanctions motion on the way, which would end the case, I'm going to file my own request for dismissal on April 15th, 9 days, I think it was, before the motion is to be heard. And therefore, if the case is dismissed, and so Chille is thinking, the case is over, and therefore there's no basis to hear the motion. Not so fast. That lawyer was quick to respond and said, no, I want my motion heard, and he can't do this. But as the cases cited above reveal, and a concurring justice in Franklin observed, courts have construed the phrase commencement of trial to encompass any procedure that is potentially dispositive, including demur, summary judgment, or a pending motion for terminating sanctions. And by the way, Chille, this will hurt even more. This is a second district case, right in the district where you are filing your appeal. So the district court will pay great heed. And I'm sure there's only 10 published decisions on this, but this one's coming right from the second district. So they got direct authority that says that you are wrong about this central issue. Let me see which court within the second district heard this. Let me get rid of this messy thing here. Give me a second here. It'll tell me the judge and everything. Division 1, LA County. Yep, that's what I thought. LA County couldn't get any better than this. Division 1's LA County, and you are appealing from a decision in LA County, and that's it. This will be quoted very quickly in the motion, the respondent's brief, which they have to, by the way, they have to give you a notice if they're going to send request terminating sanctions motion against you for filing frivolous appeal. But because you called it an absolute right, and because there is very recent case law that goes back, in fact, that says you do not have an absolute right to have your dismissal motion entered, and especially in the face of terminating sanctions, you're going to lose on that. Okay. I just wanted to show the case that's going to immediately fuck up Chille's appeal. And let's go back and take a look at a few more things, and then I got to wrap up, got other things to do. All right, so here was the dismissal that Chille entered on April 15th. He filled it out right. He wanted Clement Piratini and David Omo out without prejudice. In normal cases, that would be fine, what Chille did. But this was not a normal situation because they were facing down him. He was facing down Piratini's motion for terminating sanctions. This is a little bit strange. This one was filed by Chille on May 19th, but it was rejected because it doesn't have the name of the plaintiff and the defendant, so the clerk could not do anything with it. Here was the court order on July 3rd, 2025. And so Chille appeared, you know, he went there. I give him credit. He definitely fought this case hard all the way. Oral argument, court orders. Piratini's motion to vacate or strike plaintiff, voluntary dismissal without prejudice is granted. So I just showed you that dismissal that Chille entered. All right. So this was vacated and struck by the trial court, so that there's no longer a dismissal. Court orders dismissal of the case without prejudice entered on plaintiffs, blah, 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 as to Piratini only. The request for dismissal of the complaint without is again remains entered effective. So the others are dismissed from the case without prejudice, but they could be dismissed because there was no terminating sanctions motion. They didn't do anything to challenge it. Why would they? They've been dismissed from the case. But what happened here for Piratini was his lawyer was thinking, if you dismiss this case without prejudice, you could file it again against us. And if we get a terminating sanctions dismissal with prejudice, you can't file again. And that's what this lawyer was trying to do, is make sure that Chille could not file this case ever again. It says the motion for terminating sanctions is granted. Well, we all know from just the case I showed you there in the LA District Court where he had his case heard, that district, in the face of a motion for terminating sanctions, you do not have an unqualified absolute right under 581B to dismiss the case. And the judge is right. And of the 8 claims that Chille brought, 7 had already been dismissed by summary adjudication already. So he was just down to the one, right, of publicity. But the court doesn't need to rule on the MSJ because it issued a terminating sanctions order. Terminating sanctions are better, in my book, than an MSJ, because an MSJ could be overturned just on a disputed fact, but terminating sanctions go to willful violations of court orders. That's entirely within the judge's discretion. So no need to rule on the summary judgment. We've already talked about that, And here was the proposed judgment. And so Clement was dismissed without prejudice. Piratini was dismissed with prejudice. David Omo was dismissed without prejudice. And Catherine Peter was defaulted by Chille. So all he has to do now is pursue a default judgment against her. But I'll get into that in a second. So here's what happened. Lou Bacon's lawyer did an excellent job summarizing everything that happened. Judge signed it. It says proposed judgment, but the judge just didn't cross out the footer, but he crossed out the part in the caption. Hereby dismissed with prejudice on September 17th. So that order was entered and filed on the 17th. The 60-day clock started, which gave Chille until Monday to file his appeal. He filed a few days early, good for him. Today is outside the window, so anything I say to him about this case would not, he couldn't change this notice of appeal or the grounds of it. So now he has to hope that it's written in a way that can give him more relief than maybe he wanted, that he stated. It would have been better if he had used the optional form. Because the construction and problems with it. So here it was again. I pulled it a second time. This is another problem that he's going to face is he had a lawyer representing him on July 5th, 2024, which was 5 days while he was incarcerated. He did have a lawyer, and this was 5 days before his conviction was overturned by Levitt. And also on April 15th, 2025, that lawyer stayed on the case. So from July to April, Chille was fully represented by counsel. So that, to the extent it impacts his ability to protect himself in the court, this will count against him because he has legal representation. Let me look at this one here. This is a declaration that Chille filed, and I'm going to critique it now. Chille obviously wants his dismissal without prejudice to go through and not to be struck or stricken by a court order, which is kind of funny, you know, as to Pericini. So what does he say? I currently represent myself in propria persona. I filed this lawsuit of being harassed, stalked, and publicly defamed by these guys. Okay. Conduct escalated to the point where I had no choice but to seek relief from the courts. I took this action to protect myself and to stop the ongoing harm. Okay, fine. From March 23 to July 23, I was incarcerated in Clark County. Nope. That was in 2024. And it was March 10th to July. I have the dates. Don't need to remember them. Convicted on March 19th and overturned on July 10th. So he has the wrong year. I was incarcerated. That incarceration was later ruled unlawful. They didn't really say that because unlawful means it was, what they said is you had a First Amendment right to film, even though that's not what you briefed in your appeals. So your appeal was granted on things that you weren't even properly putting in front of the appellate court, whatever. And my record has since been expunged. Well, you only expunge convictions, but and that's where the conviction would stay on your record so that you would have to report it for licensing purposes, where you could legally say, just so we're clear, an expungement, you could legally say you were never arrested unless you were applying for a license, like an accountant, a lawyer, whatever, a police officer. Then you have to disclose the nature of the conviction. So this wasn't an expungement. This was an acquittal, an exoneration, a reversal. Not supposed to be any conviction, no expungement, because you weren't found guilty. While I was in custody, this lawsuit moved forward. During that time, I did not have consistent access to legal resources. The internet. I was unable to properly respond to discovery requests or participate in hearings. Important deadlines and rulings occurred without my input. These are all conclusory statements, unfortunately, Chille. They're too high level. They do not get to the meat of things. They just kind of gloss over it. So judges reading this will not be persuaded because the important facts are missing. Anyway, I asked if the court allowed dismissal, blah, 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 understand, blah, 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 blah. So anyway, that's why that really isn't going to help at all. Let's see what the last one is here. And then this was something I was looking at for Catherine Peter. June 5th, 2023, he entered a default against her. I saw that there was a proof of service filed, but that's required, of course, before you can have a default entered. And technically, she's not allowed to participate in the case unless she wants to set aside the default. But it got a little bit interesting to me because nothing was listed as to what it was that he was seeking from her. Now, typically what this would mean is that he would not be able to get any money out of her because as a matter of due process, the person looking at this would say, if you're only seeking $100 from me, I'm not going to hire an attorney. But if you're seeking $100,000 from me, then I need to protect my rights. And here is, and you're supposed to give notice to the person you're defaulting. It's part of page 2, only at page 1. So there you have it. Major problems for Chille right away. Case law says he does not have an absolute right. This case is a bunch of drama, and I've already talked about it. So if his main argument is that he had a statutory right or an absolute right to have his dismissal against Piracini entered and therefore not be subject to the motion for terminating sanctions. He is wrong. The case law says he is wrong. The rest of it is really strange in some ways. It's kind of like reading a novel where the pages are all out of order, and it's a very boring novel to read. I will give him marks for appearing at oral argument and for fighting. He really did. So he gets marks there. What's going to hurt him, of course, is if he was represented by counsel during some of these periods of time when the motions to compel were filed. And the motions to compel, by the way, just in case you don't know, is let's say you serve discovery on somebody, like you want documents out of them and they fail to turn anything over, you have to meet and confer with them first, and unless they don't respond at all, and then you tell the judge with a separate statement of all the statements you've made, you know, all the document requests you've made and why it's necessary, and then you seek sanctions as well for the expense to draft the motion plus the $60 motion fee, and then you set it for hearing, and then you go and you prove your case. So if Chille is not providing any responses to discovery at all, then they're entitled to the response, or if the responses are just gibberish, like one of the requests for admission, admit that you are a constitutional law scholar, or that you call yourself one. And Chille says, I'm not saying he did this, this is an example. Chille says something like, yeah, and little Bo Peep lost her sheep. Well, that certainly isn't responsive to the question. It's an answer that has no basis in reality. Or if he just strings a bunch of objections or anything like that, you could then force him to, before the judge, to answer the questions. And if he doesn't, you know, then you bring your motion for sanctions because you give him a chance to fix it. That's just it in a nutshell. And that's where these sanctions motions happen. So where Chille is saying that he wants the $15,000 basically wiped out, he's got a real big problem there, because sanctions are in the inherent discretion of the court, and abuse of discretion only happens here in this state when it is irrational. Trial courts, as the appellate courts will say time and time again, are in the best position to decide whether or not the sanctions are warranted, hourly rates for lawyers. That lawyer I know is a fine attorney, $4.50 an hour. That will always be approved in LA at Moss Courthouse, the biggest courthouse. Is where I have my trial right now. Those are always approved if you got good experience. It's not excessive. It's not in the 700-800 range where judges become a little bit more leery, especially solo lawyers who are trying to flout those kind of rates. I always try to fly in on the radar under 500 an hour. I always get it approved. I don't want to quibble over $50 or $70 an hour and have any of it attacked. I'd rather it all be granted. Like I just had my my fee request approved in the bankruptcy court in LA for $30,000. I requested 32. They gave me 30. Good enough for me. And that's, you know, you have to be, this attorney knew exactly what he was doing. But one thing that Chille has in his favor, but you have to play out the facts, and I'm not going to. So you guys can do all the work for me if you want. I'm not doing the work anymore for anybody on these cases. If he was in a position where he was incarcerated and he could not have access to counsel and he could not have access to a proper legal defense, then yeah, I would see his point. But if it comes down to the amount of money that was awarded, that's purely within the court's discretion. Secondly, if he did have counsel, then that's really going to be hard for him to say he didn't have the right to have access to counsel. And most importantly, he doesn't have a statutory right to dismiss them anyway. So let's watch I'll wait for his brief and I'll read it, and then I'll read the responding brief. But if Blue Bacon's lawyer is watching this, he's probably already smiling ear to ear. He's a great lawyer. You'll see the case law already in that district is binding authority on that court and on the Court of Appeal, and say there's no reason to change it. Affirm our dismissal. Catch you on the next one.